Hi, everyone. Welcome back. This week, we're going to move on to Chapter 8, and we're going to move on to a new police procedure. So we just spent weeks talking about the Fourth Amendment, talked about search and seizure, then we talked about stop, question, frisk, arrest. Now we're moving on to a completely different procedure. So we're going to spend the next two lectures talking about the interrogation process. Okay, so let me share my PowerPoint with you. Now, to get you started to think about this, I want you to think back. So where were you? Mr. Bushin was killed and you are the primary suspect. You are going to be interrogated for this crime, okay? So we just found out Mr. Bushin is gone and we now want to interrogate you about this crime. So on a sheet of paper, answer the following questions. So on Monday, August 9th, Mr. Bushin was killed. Create a timeline of what you did from the time you woke up until the time you went to bed. List all the places that you went and list every person you talked to and summarize what you said to each person. Okay, so stop the video, make the list and see how much you can write down. So hopefully you're back. And I would not be surprised if there wasn't very much that you could write because that's the problem. We tend to not remember. Now, if I asked you yesterday, you would probably have a much clearer memory. If I asked you last Monday, you may have an idea of what you do every Monday. So you could kind of come up with a general summary of what you did based on what you did in every Monday. But that's not necessarily what you remember that happened. That is what you think you did because you do the same thing on Mondays, okay? So it often gets difficult. So one of the things we're going to talk about is faulty memories. And when you have faulty memories, it often leads to difficulty in recalling information when you're being interrogated. So I post this video, Don't Ever Talk to the Police. I posted it online. So I want you to stop the video and watch it. It's like 15, 20 minutes, but it's really, really good. So I don't usually require you to watch videos, but I would really like you to watch this one because he really goes through all of the reasons why people shouldn't talk to the police. And that's not really what my point is. My point is to show you how inaccurate interrogations can sometimes be, which is an important thing to think about. Okay, so stop the video. Click on that within the materials and watch that. And then when you're all set, come back. Okay, so hopefully you're back. And now we're ready to actually get into the legal analysis. Okay, so we're going to talk about interrogations and confessions today. And I like this quote: the lessons parents preach is that while a misdeed, even a serious one, will generally be forgiven, a failure to make a clean breast of it will not. Every hour of the day, people are being asked to explain their conduct to parents, employers, and teachers. Those who are questioned consider themselves to be morally bound to respond, and the questioners believe it to be proper to take action if they do not. So the reason why I post this quote is because it's really important to realize we are pretty much taught since we were little kids. It's super important to confess. If you did something wrong, just tell me that you did something wrong. But when it comes to actually the criminal justice process, you don't have to do that. And there are certain guidelines and rules that exist that police have to follow when they are interrogating. So they're not exerting undue pressure on a person. And that's what we're going to talk about. So we're going to start at the beginning. My first question is, what is an interrogation? So we're talking about interrogations. Let's define interrogation. So what would be an interrogation? An interrogation is information gathering activity of police that involves the direct questioning of a suspect. And the purpose of an interrogation is to gather information, to gather incriminating information against the person, okay? So an interrogation is directed towards a suspect. So you don't actually conduct an interrogation unless you believe that the suspect is involved in the crime in some way. So think about that. How would that be different from an interview? Well, an interview is really gathering information solely for the purpose of gathering that information. It is not to gather incriminating information necessarily. Okay. So when you're interviewing, you're just talking to witnesses and talking to people and trying to just figure out what's going on. It turns into an interrogation when you're trying to gather information that could be incriminating because you think the particular person is a suspect in the crime. So what is the main purpose of that interrogation, which is different from an interview? It is to get a confession, which is always our hope. We hope we can get a confession, but those are pretty rare. It's very rare to get a confession from somebody. So the other thing that we're trying to do is get incriminating statements. So if I ask the suspect information or questions and they answer in a way that I know is not true based on other evidence that I have, that's an incriminating statement. And that is just as good as evidence in court as the confession, because you can show the jury, look, we know he told us during the interrogation he was not there, but we have a video showing him there. And so that can be very persuasive evidence to a jury to convict when you have inconsistent or incriminating statements. So when do people confess? Well, you could just have people confess to the police, right? Somebody could just openly confess to the police. But a lot of times what they do is they confess to friends or associates who then report it to the police. So they tell a friend or somebody they work with what happened, and then that person then reports it to police. But it's a confession that they made to the person. You can plead guilty and confess in court. So if you strike a plea bargain and you're standing in front of the judge, you can say, I'm guilty, and you can confess at that point. You can make incriminating statements during the sentencing. So once you're convicted and then you're sentenced, they allow you to speak during the sentencing, and you could make incriminating statements then. But the one we're going to talk about today is confessions during police interrogation. So these are confessions that people make directly to the police. So let's talk about some general information about interrogations. First of all, interrogations rarely coerce suspects to confess. So I know on all the movies, they show interrogations and it looks like they just bully people into confessing all the time. But we said, remember that confession is pretty rare. So very rarely does the interrogation actually lead to a confession. It often just leads to incriminating statements. Number two, almost all interrogations last less than an hour. Although we're going to watch some of the wrongful conviction things when we're doing our wrongful conviction project. A lot of times that is not true. They are very short. Number three, only 1 in 4 suspects actually invokes Miranda. So we're going to spend a lot of time talking about Miranda today. And the ironic thing is we have these rights, but only 1 in 4 people actually invoke them. And 64% of suspects interrogated after they waive their rights then do incriminate themselves. So even though we have Miranda rights, a lot of times people waive them, 64% waive them and then incriminate themselves in some way. So if you watched the video that I posted at the beginning, you saw that it was very, very easy for people to incriminate themselves. And that's why it's better to always invoke your Miranda rights. Okay. So then we want to talk about interrogation. What constitutional amendments are we referring to when we talk about interrogations? We're talking about the 5th, 6th, and 14th Amendments. So we have been spending a tremendous amount of time talking about the 4th Amendment. We spent weeks and weeks and weeks talking about the 4th Amendment. Now we're going to talk about the 5th, 6th, and 14th Amendments.
This is well.
Oops, sorry. Okay. So that's what we're going to focus on, these 5th, 6th, and 14th Amendments. And we're going to talk about how they affect interrogations. So to get thinking about this, what do you think about this? Jackson is arrested and taken into the police station. It is the second time he was arrested, but the last time there was not enough evidence to hold him. When he arrives, he requests an attorney. The police refuse him, and he eventually confesses to the crime after hours of questioning without his attorney. So what do we think about that? do we have the right to an attorney during the interrogation? So we know with the Sixth Amendment, we do have the right to counsel. So the Fifth and Sixth Amendments both contain many, many parts. The Sixth Amendment gives us lots and lots of procedural rights during the trial. And one of the things we know is the Sixth Amendment right to counsel exists for the trial. So we always know we have the right to counsel, a right to an attorney during the trial. But the question always comes up, when does it actually kick in? Does it not kick in until the trial or preparation for the trial? Or does it occur at an earlier stage? So in our example, when he's first arrested in interrogation, does it kick in during that phase? And this came up in a case called Escobedo. Excuse me, still fighting a little. Okay, so Escobedo was about this man, Danny Escobedo. And Danny was accused of shooting somebody during a robbery of like a convenience store. And they arrest him and they bring him in and they question him. And after extensive questioning, they don't really get anything from him. And they don't have enough to hold him or arrest him. So they let him go. And so Danny is smart enough to go out and hire an attorney. A couple of weeks later, they feel like they have more evidence. So they bring Danny back into the police station and they start interrogating him again. At this point, he says, I want my attorney. And they say no. In the meantime, his family had called the attorney and the attorney showed up and was in the lobby saying, I want to see my client. And the police said no. So after hours of questioning with the attorney there, but not being allowed access with him requesting attorney, he finally then does confess. And they want to use the confession against him at trial. So this goes all the way to the Supreme Court. And the Supreme Court says no. The Supreme Court says your right to counsel starts prior to trial. In fact, it starts during the interrogation process. So if somebody is being interrogated and they request their attorney, all questioning has to stop until the attorney is present. Okay. So you do have the right to counsel during an interrogation. And that came up in the landmark case of Escobedo. Okay. So when you know that as the rule, let's think about these scenarios. Suspect says, maybe I would like an attorney. Police say, are you sure you want a lawyer? Man says, no, I don't want a lawyer. So let's think about that. Maybe I would like an attorney. And then they say, are you sure? And they say, no. Is that somebody actually claiming their right to counsel? Or is it okay for the police to say, are you sure? Court said, it's okay because you have to unequivocally assert your right to counsel. So if you're wishy-washy, I'm not sure, I don't know if I want an attorney. If you're wishy-washy at all, then the court is going to say that's not really an assertion of your right to counsel, and therefore the police can still question you. What about this? Suspect is given a lawyer and talks to the lawyer, but then when the lawyer leaves after meeting with the client, the police come right back in and start questioning again. Is that okay? And the courts said no. Once you have a lawyer, no questions can be asked of that person until that lawyer is there. So just when the lawyer has to go home that night, doesn't mean that they can start questioning. No questioning can occur at all anymore unless their attorney is there. Okay. Now, a group of men are arrested, indicted, and retained counsel for smuggling drugs. Co-conspirators agree to cooperate with police to get a lenient sentence. He agrees to tape record another co-conspirator. Can they use that tape recording in court? So you have two people that both assert their right to counsel. They want an attorney. They get one to turn on the other, and then that one goes in and secretly talks to the co-conspirator and tries to get them to confess. Can you do that? Court said no. So you are a governmental agent, or the co-conspirator would be a governmental agent working for the government at that point, and that would be questioning by the government. And once you assert your right to counsel, the government cannot be questioning you. So this would not be okay. What about this? Jackson is 12 years old, is arrested, taken to the police station. He is questioned for several hours without his parents or an attorney. For the first couple hours, he continues to say he did nothing wrong. Police then tell him they will let him go if he just confesses, so he finally does. The police never inform him that he did not have to talk to them. So what do you think about that? Well, that leads to the second question. So this one, he didn't actually request an attorney. Okay. So now we have to talk about the second part that goes with interrogation, which is your Fifth Amendment rights. So Fifth Amendment also includes lots and lots and lots of different provisions. And one of these provisions is the right against self-incrimination. Okay. So you have the right not to be a witness against yourself, which means they can't force you to make statements against yourself. You have the right against self-incrimination in the Fifth Amendment. So the question then comes up, you have this right, but do the police have to tell you that before you are questioned? So if you think about your constitutional rights, people aren't really required to be told their constitutional rights, right? We just have them. Police aren't going to come up to you and say you have First Amendment right to free speech. Oh, you have the right to bear arms. They're just not going to do that. So, but do they have to tell you about your right against self-incrimination prior to interrogating you? So this came up in another landmark case where Ernesto Miranda was the defendant, and he was 23 years old. He was accused of raping and sexually assaulting a young girl. His education level was only ninth grade. You know, he had some intellectual disabilities. He was indigent, which means poor. So he was very poor, and he had a mental instability also. So the question was, so they suspected him of assaulting and raping this young girl. So they bring him in to question about that girl. And they question him for hours and hours and hours. And after many, many hours, he finally confesses that he did that. And his attorneys then take it to the Supreme Court and say, you know what, based on the circumstances of this case, the police should have told him that he had the right to remain silent. That should have been told to him during the interrogation process. And the Supreme Court agreed. The Supreme Court said that once a suspect is in custody and prior to being questioned by the police, the suspect has the right to be informed of both the Fifth Amendment right against self-incrimination, the right to remain silent, and the Sixth Amendment right to an attorney. And this has collectively become known as the Miranda warnings. Okay. So prior to questioning, if you're taken into custody, they need to tell you these two specific rights. Now, these are your Miranda warnings. So if you want to know them, you can read them. Most of you probably know them. The one thing I want to point out is that last question. Do you understand these rights? Remember that question, because in the next lecture, we're going to talk about waiver. And that question is going to be really, really significant to the analysis. Okay. So what other constitutional rights do police have to tell you about? None. So people were really, really mad about this decision. People felt like this decision swung really far towards individual rights and thought, this is not right. We don't have to tell anybody about their rights, other rights. Why do we have to tell them? So a group of public order people spent their lives dedicated to overturn Miranda and get the Supreme Court to revoke it. So when Miranda came out, it was a more liberal individual rights court. And then, so they waited till it was a more public order conservative court, and they brought this case up, Dickerson versus US. And what happened in Dickerson is you had Congress pass a law that says you no longer have to read Miranda. So Dickerson's arrested, not read Miranda, and is interrogated. And it goes all the way up to the Supreme Court. And everybody thought the Supreme Court was going to throw out Miranda, but the Supreme Court upheld it. And what they said is it has become so ingrained in our society, it's so much part of our lives and our society, that we're still going to require Miranda. So you don't really hear too many arguments against Miranda anymore, because it is a pretty firmly established precedent. So remember then, whenever you're talking about interrogations, before Miranda have to be read, two things have to exist. You have to have what's called a custodial interrogation. So number one, you have to have custody. So the person has to be in custody. And number two, you have to have an interrogation or form of questioning. If both things do not exist, no requirement to read Miranda. So let's talk about each one individually. Before we do that, let's just think about how did the Supreme Court, when it was looking at these cases, balance public order and crime control? Because that's our theme for this class, right? So in Miranda, it's cited much more towards individual rights. So we're putting additional requirements on the police and giving more individual rights to people and upholding individual rights. Okay, so let's look at the first thing. What qualifies as custody? So remember, custodial interrogation, we need both things. So first thing you have to show is custody. Is the person in custody? So we have to think about how would a judge determine if the person was actually in custody? Well, they're going to use the same standard they created for arrest. So that's why arrest and custody often end up being interchangeable concepts. So what is custody? Custody would exist when a reasonable person would no longer feel free to leave under the circumstances. So the exact same test that we used for arrest. So what factors would help determine custody? The same factors we went over for arrest. How many officers? Are they holding a weapon? Is their hand on a weapon? Are they touching you? Are they moving you? Are they keeping you for a very long time? So the court's going to look at all of those different factors and use those factors to determine whether or not the person is in fact in custody. Okay. Now think about this. These are situations where if you did that analysis, you would probably conclude that it was custody. But the Supreme Court has specifically exempted these from custody. So what the Supreme Court has said, in these four situations, there is no custody, okay? So the first one, detaining drivers or passengers during a routine traffic stop. So they pull you over for speeding and they're detaining you. You would think, yes, definitely custody, don't have a freedom to leave. But the court said, no, we're not going to call that custody. So no need to read Miranda's when you pull somebody over. Administering DWI tests. Obviously, you would think, yes, a person is in custody. They're being forced to walk a line, answer questions. They can't leave. But the court has said, no, we're not going to call that custody. The next one, requiring probationers to go to their probation officers and report and talk. You would think that's custody. They're forced to do it. They have to do it. If they don't, they go to jail. Supreme Court has said, yeah, we're not going to call that custody. And then detaining a person during the execution of a search warrant, which we talked about. Remember, when they're executing search warrants and they're looking, they can detain the person and even handcuff them if they need to while they're doing the search. And you would think, oh, that's definitely custody. Supreme Court has said, no, we're not going to call that custody. So it's really kind of just what the Supreme Court has decided as the rule. It's not like if you follow the actual analysis and the test and the standards and factors for arrest, you would probably conclude that all of these are custody. But the Supreme Court is going to say, no, we're not going to include these things. So what about this? Williams is arrested for killing a little girl. While being transferred to the police station, the police officers in the front seat made comments like, it sure would be nice if we could find this little girl and give her a Christian burial. It sure would be nice if her family had some closure. So when they arrested him, he invoked his right to remain silent and his right to an attorney. And so while they're driving to the police station, these two officers are speaking in the front seat pretty loudly so the person in the back can hear. And he hears them say this, and then he blurts out, okay, I'll tell you where the body is. And he tells the police where the body is. Around the exact same time, there was a group of people that were looking for the body, okay? And we're really close to finding it. So the question here, we looked at this case and we said, This was the exception to the exclusionary rule in inevitable discovery. So they were just about to find the body. But the case, when it first went up to the Supreme Court, had to decide, was this an interrogation? When the two officers are in the front seat talking loudly, is that in a form of an interrogation that is occurring after the person already asserted their right to remain silent and their right to an attorney? Because if we call that an interrogation, that's a violation of Miranda. What about this one? An officer just arrested a man accused of raping a woman. While in the police car, a police officer is talking on the radio to dispatch. The dispatcher comments, "Is that the guy that raped all of those other women?" And the accuser in the back seat quickly stated, "I didn't rape those other women. I just raped this one." So again, you have a man in the back seat who's already asserted his rights. And then this dispatcher is speaking very loudly, accusing him of committing certain crimes. So then we have to decide, is that a form of an interrogation for the dispatcher to be speaking like that? And this came up in this Brewer and Nix case. So they combined those two cases and came up with one specific rule. And what the court said is, if the police are speaking or making statements that are likely to elicit a person to respond, that is going to qualify as a form of interrogation. So you think you're being tricky and making comments and not asking direct questions, but you're implying and making statements to sort of agitate the suspect, and then they blurt stuff out. The court has said we are going to count that as a form of interrogation. And if you read Miranda and they asserted their rights, this is a violation of Miranda. Okay. So you have to think about when somebody wants to remain silent or wants an attorney and you make statements, you could be violating Miranda because that is a form of questioning. Okay. So just as a review, remember, in order to determine if you have to read Miranda, you have to figure out these two things, custody and interrogation. So when you're answering problems, which we're going to talk about in the next lecture, that's the first two steps you have to evaluate. You read the scenario. Number one, you have to make a determination, was the person in custody? And number two, was it a form of interrogation? Each one of these has to be analyzed separately in your answer. Okay. So what about this? Based on that standard, what if a police officer is just on a street and somebody runs up and says, "I just killed my wife"? Did there have to be Miranda in order to use this as a confession? So number one, was the person in custody? No, they just ran up to the police. So no custody, no need to you read Miranda. So you can use this statement against them in court. What about collecting blood, fingerprints, handwriting samples, forcing somebody to read something? Is that a form of incrimination, right? So you may not be actually speaking, but you're giving incriminating evidence against yourself by turning over these things. Do you have to read Miranda? And the court said, no, not for this, because there's no actual questioning. There's no interrogation. You may be in custody, but you're not being questioned. What about this? Questioning done by ordinary citizens, not governmental agents. No custody. If your friends ask you and you tell them, there's no custody. Okay. What about questioning by an undercover police officer? Well, it could be if you're in jail or if you're under arrest and they put an undercover officer with you and they're asking you questions, that could be a form of Miranda, a violation of Miranda. You're in custody and they are questioning you. Okay. Now, if you're in custody and they don't say anything and you just spill your guts, then no. But if they're asking you questions, yes, violates Miranda. What about questionings during a stop? No, because we said that's one of those things the court expressly excluded from it. What about questioning probation officers or parolees? No, because we said that's expressly excluded. What about asking routine booking questions? So when you're arrested, You're taken to the police station. They have to book you, name, address, phone number. They have to fill all that information out on your arrest report. So you are in custody and they are asking you questions, but do routine booking questions qualify as an interrogation? And the court has said no. Okay. And then what about questioning done by informants? It depends. Is the informant working for the government? Are they a governmental agent? Is the person in custody? And is it a formal form of questioning? Okay. So that's the analysis you have to go through. Now, oops, I think I skipped a slide. So look at this example. A woman claims that an armed man raped her and then ran into a nearby store. Police enter the store and stop a man that fits the woman's description. The police handcuff him and frisk him and find an empty gun holster. The man then asks, the police officer then says, "Where is the gun?" And the man says he threw it in the garbage. So, number one, custody. Is he in custody? Well, yeah, he's being handcuffed. So you clearly have custody. Second thing is, was there a questioning or an interrogation? Yes, he was asked, "Where's the gun?" So when the man says he threw it in the garbage prior to Miranda's being read, does that mean that statement is thrown out under the exclusionary rule? And then ultimately the gun, because you only found the gun based on that statement. So fruit of the poisonous tree, would that exclude the gun also? So this came up and the courts created what's called the I'm sorry, it's blocking. My thing is blocking it. But I just want to make sure I say it right. The public safety exception. I'm sorry. So the public safety exception is an exception that's made to the Miranda warnings. Now we have lots of exceptions for search and seizure. We don't for this. This is the only exception. And this is your word for this week's lecture. Public safety exception. Keep having public order in my head. That's what was throwing me. So public safety exception is the word for this week. So make sure you send that in to me. So the public safety exception is a very narrow, limited exception. It can only apply if there's a true emergency endangering the public, and it's only for a very limited purpose of finding out information. Okay? So if you remember the Boston Marathon bombing, when they finally arrested Tsarnaev, they actually took him into the police station and interrogated him for quite a while, asking him questions like, are there more bombs? Where's the bombs? Where did you hide them? Where did you make them? And asked some specific questions that were directed totally towards public safety to try to keep the public safety. And sometimes they deliberately try not to read Miranda's because they don't want the person to invoke an attorney. Now, you can't do this just to get around Miranda. There has to be a legitimate danger to society, and it has to be very limited questions. Now, in that case, they didn't read them for days and they questioned them for days. So there was always that question of, were they going to be able to use what was said? Because are they going to give that public safety exception that big? And it didn't matter because he pled guilty, so it didn't come up. But in the past, the Supreme Court has read it as a very, very narrow exception. So I would not push it. If you push it too far, the court's going to say it goes beyond the exception because it's a very, very small, limited exception. So again, then, how does the court balance the rights between public order and crime control? Well, with the public safety exception, the court swung a little bit more towards public order. The need to keep the public safe, the need to keep them maintain order and protect people is going to weigh a little bit more than the violation of your right. So in that case, that balancing is going to go a little bit more towards public order. Okay. So what about these Mirandas? You have the right to remain silent. If you give up the rights to remain silent, anything you say can be used against you. In a court, you have the right to talk to a lawyer before answering any of our questions. If you cannot afford to hire a lawyer, one will be appointed to you without cost. And before any questions, you have the right to use any of these rights anytime you want during this interrogate interview. So these are a little different. They were not the exact words. So for years, everybody said you have to read Miranda exactly as it's written, word for word. So officers would keep it in their hats or in their pocket and whip out their card and read it word for word because they were afraid if they messed up any words, the court would say it was not proper Miranda. So this was challenged to the Supreme Court. Is this going to be okay? And the court said yes. So now they're a little more lenient on the words as long as you specifically convey the information. Even if you don't use exact words to do it, you're probably going to be okay with your warnings. Okay. So that is the first lecture. So you have an interrogation flow chart that I posted. I strongly recommend you print it out and that you use it on your homework. For the first part, we've only done this first part of the analysis. So the first step is to determine if Miranda even has to be read in the first place. Does the Miranda kick in? So remember, number one, you need custody. Would a reasonable person feel free to leave? If no custody, no need for Miranda. If you have custody, then you go to the next box. Was there an interrogation or the functional equivalent? That is, did they ask you questions that were likely to elicit a response? That's what's called the functional equivalent of an interrogation. Okay. So that they say something to you likely to get you to say something. If yes, then you have to figure out where Miranda's read. Okay. Well, this is just the first part. We're going to take it to the second part of the analysis in the next lecture. But for right now, I just want to make sure you understand that your analysis has to include these two things. So I posted some problems online. You should try to work through those problems and see if you're getting those two parts of the analysis done before watching the last PowerPoint. Okay. So that's all I have for today or for this lecture. So the next lecture is going to talk about the concept of waiver, and then we're going to do some problems together so you understand how you're going to answer your interrogation problems. So I hope you enjoyed this lecture, and I will see you soon with the second one.